kind of key guidance that we have in the region, many of which I think are referenced within the model law. So just then a quick introduction to some thoughts of my own, given this context, given the regional norms and standards that we have, what should oversight of prisons pay specific attention to in order to protect LGBTI rights? Firstly, even should it identify and recognize LGBTI people as a specific vulnerable population? I would argue LGBTI, as well as some additional populations, definitely should be specifically recognized because they may require specific safeguards. They may require those doing oversight to really pay attention to what is the situation in prisons. So oversight of the treatment of LGBTI communities in prisons means looking to make sure that specific measures have been taken to protect them from abuse, from discrimination and violence, that they have access to the necessary healthcare services to protect their health, that they have respect for their gender identity expression, they have access to complaints mechanisms, and those should be confidential, and that there should be reporting of situations of violence, abuse, so that oversight of those reporting can take place. And another perhaps some thought on how can we promote useful oversight mechanisms. Well, firstly, they need to be independent oversight bodies. And I think this is particularly important given the context that we are in, the strong anti-rights, anti-gender pushback in many countries. We need to ensure that bodies that are going into prisons to specifically conduct oversight are independent. Secondly, they need to have wide powers to inspect, to investigate and report on all of the conditions in prisons that may create specific vulnerabilities for LGBTI and other vulnerable populations. They should have clear guidance on what they should need to monitor and look out for and the specific vulnerabilities of populations. So looking at treatment, ensuring access to healthcare, legal remedies, ensuring measures to protect from discrimination. And they must be inclusive and intersectional. So they need to recognize that LGBTI people also may have other vulnerabilities. They very often, they could be young people. They may be people living with HIV, and to make sure that any oversight also identifies the specific vulnerabilities because of these various intersectional vulnerabilities. And I think finally that oversight must also ensure that prison staff have been trained and given their own specific guidance on how to ensure that the management of prisons takes the needs and rights of LGBTI populations into account. So those are just some initial thoughts, but I know that this webinar is to discuss exactly this and what prisons oversight should look like in the context of LGBTI. So I hope that's just given some initial ideas so that we can carry the conversation further. And thank you very much.
Thank you very much, Kati. You provided insightful thoughts. I think what really caught me was the correct placement of people with LGBTIQ communities in prisons. There could be people who are misplaced in terms of their gender in prison. That is food for thought for Anneke. And also there should be clear guidelines for oversight institutions. And also I think this one came up in a lot of our sittings, training for prisons, training for oversight institutions, and training for our also prison guards, for everybody who is involved in prisons. I think now we could invite Anneke Miarkota to unpack what the model law says on the issue of LGBTI community and how oversight comes into place. Protection of LGBTI community and vulnerable populations.
Thanks so much, Ms. Malapo, and thank you, Ms. Grant, for the great introductory remarks. I won't be long on the model law itself because I think it's important that we spend our time discussing what exactly we want in it as relating to the LGBTIQ plus population. Ms. Grant mentioned the issue of independence of oversight mechanisms, and this is quite critical, and about how we consider the needs of vulnerable groups. Now, the key issue that she emphasized was around human rights and dignity, and that is really the underlying principle that ought to guide how oversight bodies assess whether prisons are compliant with international law and with national standards. Now, the universality of human rights is legally and internationally recognized, but the understanding thereof in many of our countries, as Ms. Grant pointed out, is not necessarily so well recognized. So it then raises the need, I think, within the model law itself to be quite clear on the principles that underpin it, and to emphasize the universality of human rights in the sense that they apply to everyone without any form of discrimination. Now, just to go through some of the issues in the model law, Ms. Grant mentioned complaints mechanisms and how they need to be responsive and confidential and ensure that there are no reprisals. And I think this really does raise the interesting question for prison officials who would be dealing with complaints, for them to recognize that certain vulnerable groups might have complaints that aren't necessarily the same, or requests that aren't necessarily the same as other prisoners, but that doesn't mean that it ought to be dismissed, but it ought to really be considered properly, and attention given to that. Now, I'll skip through some of the things. If we look at official visitors, which is one part of the oversight body that can visit prison institutions, I think here it would be important to include some aspect of civil society oversight, because civil society organizations are often best placed to assess whether the needs of LGBTIQ individuals are being taken care of. I think it's often what you might find is that already LGBTQI individuals who find themselves in prison might find it harder to contact their families and relatives, and it might well be that their families and relatives are no longer in contact with them, in which case there need to be other groups who are able to access them, to ensure that their needs are being met, and that this sort of access ought to not be only clerical access, but access of supportive civil society groups as well. Then judges are able to visit prisons, but judges aren't necessarily trained on issues in relation to LGBTIQ individuals. And here again, we need to look at the people who do oversight and what it is that they do. And I think the model law would be good if it could emphasize that judges need to exercise their oversight role in a way that is fully compliant with the law. So it doesn't really matter what the individual judge's views are on LGBTIQ individuals. What matters is that the judge assesses in an entirely fair manner whether or not laws are being upheld within the prison environment. And so I'll just skip through some of those things, but it is important here for judges to also look at if certain individuals are particularly vulnerable within the system, whether there might not be alternatives to detention or early release that they might qualify for it to enable them to avoid the risk of violence within the prison system itself. And I think it's that violence that LGBTIQ individuals face within the prison system is so pervasive that it is incumbent on those who provide oversight to really look at alternatives to detention where that is possible. Then we have national human rights institutions, and again, they can visit prisons and other places of detention. They would require sensitization and training. And again, the emphasis is on them upholding the universality of rights. What is quite useful, I think, is that in a country which might be where there might be a lot of hostility towards LGBTIQ individuals, and where it's not possible necessarily for civil society organizations to visit places of detention, the national human rights institutions, such as Human Rights Commission or your Ombud, are really the only people or entities who might be able to visit the facility and to look out for the needs of LGBTIQ individuals. And it's important that they understand that to fall within their mandate. There are other oversight mechanisms. I won't go into detail in relation to those. One other one that is relevant is around health professionals. So health professionals have a particular duty, an ethical duty to report if they do come across violence and torture within a prison facility. And they might have acute awareness of the challenges faced by LGBTIQ individuals within the prison facility, and that might necessitate them also raising that with the relevant authorities to ensure improvement of their treatment. Again, there's critical issues that might arise around referrals, just where people within the prison facility were able to access healthcare or weren't able to access healthcare. So often, if people are arrested and detained in pretrial detention for a prolonged period, they might not be able to access the relevant health services and treatment that they need. And it's important for those sort of concerns to be taken seriously where they are raised. And so LGBTIQ individuals fall within those groups who face additional vulnerability within the prison system. And like Ms. Grant mentioned, there could be various intersecting forms of vulnerability that make things even harder for persons in detention. So you could have LGBTIQ persons who are detained on based on their immigration status, or who might be living with HIV and requiring additional treatment, or who might be children or survivors of sexual violence. So there's many other factors that ought to be taken into account. And the key issue here is really around non-discrimination and the universality of rights. Now, I'm just skipping through some bits to get to what one would think ought to be looked at in relation to LGBTQ persons by the oversight body itself. Now, there's a lot of debate about whether a model law ought to be very detailed and sort of prescribe nuances for governments and sort of set out things that would ordinarily be found in regulations and not in substantive laws themselves, versus whether one ought to use the opportunity to actually set out in quite some detail the issues that oversight bodies need to look at in respect of LGBTIQ persons, on the assumption that there is a dearth of knowledge and much ignorance around their needs, and that one cannot assume that training or guidelines would necessarily immediately address that. So I'm raising that around the issue of detail on what people think ought to be included in the model law and for that to be discussed. Another aspect that the model law considers is around survivors of sexual violence. And we do know that LGBTIQ individuals are particularly at risk of sexual violence within the prison system. They might also have experienced violence in their past that might still impact on their mental and physical health. So this group ought to be looked at, and it's important that prison oversight bodies consider whether or not these risks faced by people have been taken into account, because legally, if a prison detains someone in a space that they know that person will be sexually violated in, exposes the prison itself then to liability. And this is something that no one wants to speak about, and few preventive mechanisms are put in place to deal with these sort of risks. But it is a really real concern that cannot really be ignored. There's also very little data available about sexual abuse within prisons to be able to attend to it properly. And there's an inherent stigma faced by LGBTQ individuals when they report sexual violence. And it might even be that the people they report to might be trained on dealing with survivors of sexual violence, but might not be attuned to the additional issues relating to LGBTQ individuals that might cause additional trauma for them. And what one then require is a trauma-informed response to all survivors of violence. So it gets us to what has been mentioned by Ms. Grant around minimum training requirements of oversight bodies and reporting requirements, and really looking at what sort of training do we think ought people to have, and again, in how much detail ought the model law to go. So, and I'm putting this out there because one can say that oversight bodies ought to be trained on interviewing and the treatment of vulnerable groups, or one can specify who those vulnerable groups are. And the risk is always, once one starts specifying, that you end up leaving out certain groups, and they then end up being perceived to be excluded by the fact that they have not been included in whatever list is supplied. Or you could have a non-exclusive list, or one can decide that given the current discussions happening around LGBTIQ individuals in some countries, that one might want to not include specific areas of vulnerability, but rather sketch out the broad principles around non-discrimination and how to treat that. So this, I'm going to stop here and just open it up for discussion on important issues people would want to see in the model law as it relates to LGBTIQ individuals. Thank you.
Thank you, Anneke, our lead consultant on the model law. We can open it up, colleagues, and hear what you would like to see in terms of protection of key populations the LGBTIQ communities. What would you like to see on the model law? You could react with your and raise your hand to talk to the forum, to Anneke, and you could also put something in the chat box. And to talk, you would please say your name and the institution you come from. We're looking for country experiences and your own experiences to enrich the model law process. Thank you very much. Also, technical experience is also welcome. Any reactions? Any reactions to submissions by Ms. Grant or to what the model law already has with Anneke's presentation? Or what we have already in our own countries? Nelly Tobeja says, greetings from Botswana. Is there a section in the model law on documentation and data collection of transgender and gender diverse people in detention centers? Data collection. I think it's just the issue of data. Matlogonolo, hello everyone. Hello Matlogonolo.
I'm sorry, Zoom is dribbling me. I was trying to find the icon for raising my hand.
Okay, it's okay.
Yeah, I was gonna talk around the issue for uniform, especially for trans diverse persons, that it also needs to be looked at to ensure that people who are incarcerated wear uniform that is comfortable for them, that is in line with how they self-identify. For example, looking at the recent case that has been ongoing in South Africa. And also something that Anneke mentioned, I was gonna talk specifically around the languaging. I was thinking that it would be useful to have Soji explicitly mentioned, especially in the accountability and the accountability mechanisms. But I understand, I'm also now reflecting on countries or context where it is not safe or where it's really, really, really hostile. But I don't know where I stand with regards to that, because I think a lot of the times when Soji is not explicitly mentioned, then it is interpreted as not being part of the non-discrimination groups. So perhaps take a deeper look at the languaging, how it is phrased around non-discrimination.
Thank you, Matlogonolo. I think there was either hand clap from Leonie or a hand raise. There was a reaction. Laon, sorry, Laon.
No, I was only reacting to what Matlogonolo had said about how when Soki is not mentioned explicitly, then it's overlooked. I
Okay,
think there's
thank
a
you.
hint somewhere else, though.
If I can respond in the meantime, Ms. Malapo.
Thank you, Annika.
On the issue of, well, let me start with the issue of data collection. What exactly would one ask? Because and how would one ask it? And this sounds a bit weird, but I would think that one would want to know person's gender identity, but you might not want to ask people's sexual orientation. Because it would not necessarily matter within the prison system unless they are at particular risk, or or if there's a way in which people can identify whether they feel at risk without necessarily it's a bit of a tricky one for me about what one would say you really want to collect data on. The second question I would have is that I would agree that within the definition of discrimination within the model law, we need to include SOGI and be very broad about the grounds of discrimination and make sure that it's included. The question then is, once it's included in a provision around non-discrimination, do there need to be additional provisions relating to SOGI within the model law itself? And I'm not asking this, I'm asking this because we're in a difficult situation these days where one don't know what to say and what not to say. And you want to make sure people are as protected as they possibly can be. And we want to acknowledge the risks that people, specific groups face within the prison system. So I'm just asking a bit more. I know that the UNDP indicated that they think it should be specifically mentioned, but I wasn't sure whether that's only in relation to non-discrimination or more broadly or more detailed than that.
Any reaction, myself, Anola?
Is the hand up? Doreen's got a hand up.
I didn't see. Oh, Doreen, please.
Thank you. No, I'm just just in response to Annika with regards to the data collection. I think that's a very important question, right? I think data collection is vital. It's necessary. And how that data, I think what should be central to how that data is collected, it should be the principle at the very least that disclosure should be completely voluntary, but also that complete confidentiality is necessary in the event that somebody discloses their sexual orientation or gender identity, and as well as to kind of as well as to acknowledge that so there is that very real vulnerability for people who do identify, whether or not they have disclosed, they do identify as part of the LGBTIQ plus community. But it's also important to understand that even if one is not a member or does not identify as a member of the LGBTIQ plus community, just them being perceived as being part of that community is also something that's really important for oversight to acknowledge, right? Based on their gender expression, if they're not neatly falling into socially assigned gender expressions, that people who are not part of that community could be targeted under the assumption of them being part of the community. So that's also really important. But yeah, the data is important, but it should always be done in a way that does not further does not further the risk or the vulnerability of members of the LGBTIQ plus community, and that it should always be voluntary. And also, even in the event that somebody is a member of the community and does not disclose or declare even to the oversight official or oversight body or mechanism, and something does happen to them, because that it should not be something that they're penalized for, right? Because they did not feel safe enough to declare. And I think these are some of the things that we really need to be thinking about. With regards to the other question, I know like this is about whether or not I do think that certainly in the principle around discrimination, it should be articulated. Also, language is very, being clever about how, maybe not necessarily in that section, but if we end up having another section where we're looking specifically at SOGI, that language matters, right? In the sense that there would be likely a knee-jerk reaction to resist, to reject the model law because, particular words or terms appear in the law, but also we do not want to exclude or to enable the exclusion of particular vulnerable groups. So I'm just thinking if we're looking at having the section, because I think we're still yet to decide whether or not we're going to have a specific section that speaks to specific vulnerable groups, to maybe frame it around, so LGBTIQ plus, we already know that people already know to react to that. SOGI potentially now, I think, especially at this level, people might be already looking out for that. I know in our organization, we also sometimes use terms like marginalized sexual orientations and gender identities and sex characteristics, right? So this captures the LGBTI, it is speaking to all sexual orientations, including, the marginalized sexual orientations, without necessarily being like a neon sign for people who might be looking out for or looking for an excuse to reject something. I don't know if that would be helpful, but that's just my 2 cents.
Thank you so much, Doreen, for sharing. Before you go on, Aneke, we have something on the chat box. Matlochonolo says, if collecting data and aggregating based on SOGI status, measures should be in place to protect LGBTIQ individuals if the data were made public. Facilities must have written policies and practices prohibiting discrimination, harassment, and sexual violence against lesbian, bisexual, queer, transgender women, and must have protective measures in place using protective guidelines from judgments such as the September or Botswana Decrim judgment. We have Caleb Mutungu. I'm still trying to work out how this can work in Malawi. Already the criminal justice system is discriminative and frowns at homosexuality. The prisons are so congested that many prioritize food and just a place to rest their heads at night, since some even spend the night standing. Anything to add on that, Aneke?
Yes, so I think let me respond to Caleb's point, which I think is entirely spot on. The conditions are so rough that in most prisons in the region that yeah, it would be hard to think about even specific measures being taken to support some groups. I would, if we look at collecting data, I want to put a counter argument that I think it would actually be dangerous to suggest in the model law that there should be data taken from prisons, because if the bulk of our SADC countries are still criminalizing same-sex acts, then any sort of data collection process by a government institution that actually asks people to identify their sexual orientation, or even their gender identity, because things are so convoluted sometimes, could put people at risk of outing and further criminalization. So I'm just wondering whether the best might be to not give any ideas to governments who, to not create a system which might have too much data. And how much data is too much data? We want data that helps us to provide services. So we want data that helps us know what sort of health services there ought to be and those sort of things. But do we need any more specific data than that? And are there risks linked to that? Because to be honest, I've seen these filing cabinets. There's nothing confidential about them. So it's not, yeah, I mean, what do we expect will be done with the data and how will it be helpful? So I'm just putting that out there because for us to discuss really about what do we really want and what could be useful for persons in detention. Yeah.
We have a message on the chat box from Nelly. To rephrase, I wanted to understand how the information provided by transgender people is used to protect them from further human rights violation in detention centers, because at the end of the day, we're looking at an African system that still addresses sex and gender in the same manner, which is exactly what you were just referring to, Anneke. Yeah. You have the floor, Doreen.
Thank you. I think, that's a very good question, Nelly. And I can only give within the South African context. And again, this is basically in principle and in policy and law and not necessarily in practice. And that's what we saw, that's what was highlighted by the Jade September case that somebody else made reference to earlier, that essentially collecting the data from transgender people, ideally, if done right, the way it's supposed to work, and if it's actually, being implemented, it's supposed to make possible their protection when it comes to housing, like which cells or which sections of the prison they're sent to. Obviously, it's also supposed to be done in consultation with them. It's also supposed to allow transgender people to their dignity, right? To be able to express their gender, regardless of which facility, whether it's a men's facility or a women's facility, and whether they're a transgender man or transgender woman or non-binary. So it's to ensure their dignity, is to also ensure that the services that are made available or accessible in the facility cater to the needs, whether it's medical. So they're supposed to be gender inclusive services that also cater to the needs of transgender persons. And this could be, obviously this is possible, right, in a country like South Africa because of the legal recognition of transgender people, even though, there's also still a long way to go there as well. And I also understand that in other countries that would not be possible. So I guess I don't know. I don't really have an answer to the question that Anneke posed, right, around the data or around whether or not how much can we put into the model law. But to just answer specifically the question asked about how this data is supposed to help, ideally is supposed to help transgender people. I hope that answers the question.
Thank you, Doreen. We have a submission on our chat box from Tiruna. I hope I'm saying that correctly. It says, so the policy mainly focuses on prison oversight processes, which means that a panel of experts will be coming in to assess if baseline standards to accessing healthcare, justice, and other basic services are available to LGBTQ people as well. In countries that have legal gender recognition processes for gender persons and intersex persons to access, change, and identifying documentation, the oversight process can include a provision under documentation access, such as the section for asylum seekers and immigrants, if it's still included. We have another one from Nelly Tobeja. A recommendation: it will be helpful to have the oversight body personnel to be trained on SOGI and human rights. This should be made mandatory to promote accountability. It will also be helpful to include prison staff, auxiliary, and inmates. Anneke, did you capture all that issues of change in documentation?
Yes, I absolutely did capture all of those. I'm wondering if the UNDP has any responses to some of the issues. Since you're here, Ms. Grant.
Look, I think the issue of data is, as you say, it's a complex one, particularly as we know that prisoners are in places of, people are in places of detention in countries where, say, being gay or lesbian is criminalized. So it is a difficult one, and I'm not quite sure. I'm not quite sure how we do it in a way that remains sensitive, but if we think about it in the health sector, it is critical that people are counted in order for services to be provided to them. So I think that we have to find ways to do it, whether it's doing it in a way that secures confidentiality and anonymity, that is simply for recording. But we know that having that data is critical to ensuring that people have access to the services that they need, amongst other things. So, yeah, that was just my one comment on that issue, which I know is a complex one.
So if I can just respond, so Kitty, would you think then that one option would be that the model law actually emphasizes that health services ought to be provided through the Department of Health? Because we know that departments of health at least have better recognition of key populations, and prison authorities are linked to the justice system, which might then encourage criminalization. So if we had a way of health services being provided and documented, and that if data is collected, that's data retained by the Department of Health, not by anyone else.
It certainly sounds, from the complexities that we understand, it certainly sounds like a sensible approach. I think it would be great to hear from people who are responsible for providing healthcare services in prisons what the difficulties would be with that. I mean, I think that we know that referring outside also means that people have got access to a wider range of services that they may not be able to access within within correctional facilities, places of detention, including mental health care services, which I think we recognize are increasingly critical. So, you know, from in terms of the concerns around data sensitivity and the access to a broad range of services, yes. But I think it would be critical to hear directly from healthcare providers within prisons of what, you know, what the problems are with that.
Yeah. Thank you, Kitty. Anything else, colleagues? Any more submissions? Anything you wish to go see into the model law? We have something on the chat box from Rainbow Identity Association. Says very true, Kitty. People outside prisons can access services more than in prisons, especially the trans community in countries that do not recognize trans.
Yeah. Can I say something?
Sure.
Yeah, but it's not necessarily with regards to trans people, but it's just in general to detain people in detention with regards to families. I know that in Botswana, when children stay with their mothers up to the age of 14, meaning even boys. And then after that, they are moved, boys are moved to the men's accommodation or cell. I don't know how to put it. But, you know, we hear, it's not that I witnessed anything, we hear that there can be abuse of boys by men there. So I wonder if that's something that you could consider to tackle. I don't know how this would be done, whether it will be possible to build a unit just for young boys, you know, because there's no reported cases of, or there's no rumors with regards to girls staying with women that there has been any abuse. The abuse is more of boys staying with men. Thank you.
Thank you, Tiny. Any more submissions or Anneke, any responses to that?
Yes, if I can just come in, the principle is that adults and children ought never to be detained together. And obviously, if our oversight body does come across such a situation, that has to be addressed immediately. And I think oversight bodies generally do know that that is something that ought to be addressed immediately. So even where people of different ages are detained within the same facility, there ought to be some separation. And definitely adults and children cannot be detained together.
Unless they are families.
Lovisa has a hand.
Lovisa, you have the platform.
Thank you and good afternoon.
Good afternoon.
I'm sorry for coming late. I was having issues with my internet, but I just wanted to comment or to confirm what Anneke has just responded to. Normally, the juvenile, okay, in my country we call it the juvenile. Sorry, I'm Lovisa from Namibia. And the juveniles are not incarcerated with the adults. And in our case, where we are having different units, where we make them to say there is a lower risk, medium risk, and the high risk. There is should we say a tools that they first come to reception and assessment, their risk and assess their risk and needs are being assessed, and they are put to the living units based on their risk as well as on their age. So juveniles are not incarcerated together with the senior or the adults. So, and maybe in our case, we have never seen young girls that are imprisoned. I cannot recall a case of having young girls or juveniles girl, but again, in case they come in, there's always a cell or a unit for them. So that one it's normally happening already. Thank you.
Thank you, Lovisa, for that submission and confirmation. We have a question from Rainbow Identity Association. We would like to hear if anyone has ever come across a detention of intersex person whose physique does not respond to their recorded sex. I guess that's a question in a way. Anyone who has come across? Were you coming on, Tiny?
No. Well, yeah, just to make a correct, well, maybe a clarification to Lovisa that the reference I made were for immigrants. It was just a follow-up of this morning's, not just any other person in detention. Thank you.
Thank you very much. Any other submissions? Doreen?
Yes, I'd like to come in and speak to Tiny's very important intervention, right? I mean, Annika has already addressed it, but how things should go. But I mean, we know that it does happen where things are happening opposite to how they're supposed to be done, right? I don't know about all the countries in the region, but I think immediate intervention is important, but there might need to be some kind of recommendations on what that immediate intervention could look like. And I think because this then would require other government departments to come in, right? So yes, that child should be removed immediately. And when they're removed, then there needs to be an understanding of where they should go, right? And I think this is a problem that we find also just outside of the conversation around prisons. I know that this has been an issue even in shelters for abused women and children, where young boys at some point are expected to leave the shelter, right? Once they reach their teens, because they're already perceived as potential, I don't know, potential threats or potential harm or perpetrators, but there isn't really much then available, like safety options available for them when they leave. So I don't know. Yeah, so this is also a question, I guess, for anybody else here around how we can address this, because we know what the international laws say, we know what the right thing is to do, and we want it done. But I mean, yeah, we also need to make sure that we have a solution that kind of gives guidance as to how it's done, or in what ways it can be done. And to answer the question about if anybody's ever encountered intersex people or an intersex person who's been in detention, yes, our organization, we have encountered, but it was in police holdings, so not necessarily prisons. And this was an intersex person who identified as male, but their sex assigned at birth and the gender identity imposed on them was female. And they experienced harassment whilst they were in police holding. So I don't know if that was the point of the question, but to say yes, we have as an organization been approached by an intersex person whose gender identity did not match with the one with the sex assigned at birth.
Thank you, Doreen, for your submission. We have one on our chat box from Nelly. Thank you for inviting us to the discussion today. One last suggestion or recommendation: reports from the oversight bodies that have recommendations must be handled with urgency, no delays to justice and redress. Rainbow Identity Association says we can see it's very difficult, one, because of the issue of data. Ladies and gentlemen, I think if there are no more submissions or interactions, we can come to the end of our session. We can still interact with our drafter, Anneke, through emailing her at prisons@sadcpf.org to share our technical experiences, country experiences, and best practices to inform and enrich the process of this model law. I think with that, we can come to the end. I think we have one last submission from Tiruna, which says, we hope there will be a very strong inclusion of the LGBTQ issues throughout the policy. I think our submissions today will have informed Anneke, and even when she says, even where there is explicit mention, there's measures which can be taken to ensure that health and sexual violence provisions are open-ended to allow expansive interpretations. Laone says, thank you for inviting us. This has been an enriching engagement, and it is truly commendable that the law is progressive and moving to include the Mandela and Bangkok principles. Thank you very much. And Tiruna Naidu, thanks all. We thank you very much for your participation today. Thank you so much for taking the time. Thank you to Ms. Kitty Grant and Anneke.
I have
Thank
the
you,
last
ladies.
question.
Question.
Yeah.
Okay.
How will this law work in countries that do not recognize LGBTs?
Anneke, would you care to address the question?
So the law, as suggested by Teruna as well, is that it's important that we have open-ended provisions which around health and violence that can be applied in all jurisdictions, that we emphasize all the various international treaties and minimum standards, including those mentioned by Ms. Grant from the African Commission relating to intersex and persons and SOGI, and that we then have a discrimination provision that specifically includes SOGI as a prohibited ground of discrimination. So that's roughly it. Yeah, I hope that answers the question.
Are we settled, Tiny?
Well, yeah.
Tiruna says, thanks, all interesting question. Even if there's criminalization of the community, there's still an obligation to protect people from specific forms of targeted violence, and the Resolution 275 and 552 guide how human rights standards for criminalized communities can be upheld. Thank you for that, Tiruna. Thank you, ladies and gentlemen, for enriching the model law process on the LGBTQI and key populations. Thank you so much. I think ICT can end our session.